It's Columbus time. Let's get started. My name is Hersemann. Today I'm talking about fair use and other legal issues in video games. And sometimes my clicker works and I can go from slide to slide. But the rest of the time it doesn't work. And then it's embarrassing. Yeah, that doesn't work. Come on. Bam. All right. CV. So, my name is Hersemann. I am the founding partner of Loading Law, a video game-centered law practice out of Chicago, Illinois. I also organize the Chicago Video Game Law Summit, which is a one-day conference all for video game law issues. When I'm not losing sleep over those two things, I'm also working with the Video Game Art Gallery and the IGDA Chicago. Very important things, Twitter and email. If you're taking any photos today, please do. Feel encouraged to take photos. It makes my life a lot easier when it comes to marketing. Tweet them at Loading Law. Use the hashtag GDEX 2016. It's a good spot as well. And if you need to find me after the fact, after today, if you have questions, if you have comments, I have business cards here, and you can also find me at both of those places. So, now that we got that out of the way, this is what we're going to be talking about. Today we're going to be talking about copyright generally, fair use specifically. More to the point, when can you use third-party content? If there's something out there that you didn't create, how and when and where can you use it? We're also going to be getting into what laws cover that content, specifically the federal and state laws that get into all of your copyright issues. It's mostly federal. Copyright isn't a state thing. And we're going to be getting into some general good business practices that can help you avoid a lot of the common pitfalls that apply to video games. This is the first disclaimer that I'm going to make today. Lawyers love disclaimers. Though I am an attorney, I'm not your attorney, at least not yet. So anything I say today is legal information. It's not legal advice. Don't feel like you can rely on this information right now until you and I have a one-on-one conversation to talk about the more specific situations involved in what you're doing, because there's always exceptions, there's always differences. At the end of the talk, I'm going to leave a lot of time for questions. So if you have questions later at the end of the talk, try to make them a little bit general so they can apply to everybody. Don't get too deep into something that you're curious about. So, I always have to start with some legal basics before we start talking about fair use, because believe it or not, there are a lot of different areas of the law that apply to video games. For the most part today, we're going to be talking about copyright. Copyright applies to a lot of the things you see in video games that are visual. The music, the sound, the written words, all of that falls under copyright. Trademark is a whole other thing that applies to the branding of games. So, the name of your company, the name of your game, the brand logos. All of that falls under trademark law, completely different section of law with whole different regulations. After that, to a lesser extent, I'm not going to be getting into it so much today, but if you have questions, I welcome them. Patents, also very prevalent in video games, especially when it comes to hardware. Any kind of custom controllers, interfaces, the Nintendo Switch, very high-profile thing that has to do with patents. And lastly, and one of the most common areas of litigation right now is privacy and the right of publicity. What we get into there is a lot of regulations related to minors using video games, especially games that have gambling elements, and also celebrities who are either in games or not in games, either because they want to be or more often than not because they don't want to be. Think Lindsay Lohan, Emmanuel Noriega, a lot of these folks don't want to be in video games, find themselves there, sue over it. All of that comes under the right of publicity. So today, for the most part, like I said, we're talking about fair use and copyright. Copyright is an original work of authorship transfixed in an original medium of expression. What that means is that it has to be permanent somewhere. If it's a song, it has to be stamped on a disc. It has to be saved on your hard drive. If it's a story, it has to be written down. Public performances are not copyrightable. Now, the video of those public performances, that is copyrightable. But the point is, it has to be permanent and replicatable. That gets very important when we're talking about elements of video games that you can't recreate. When there's unique elements of video games that you can only see once, it gets a little bit tricky. Duration of copyright, also very important. It lasts the life of the author plus 70 years, which is a very, very long time. Unless it's made by a corporation, then it tweaks a little bit. But it's important to keep that in mind because since we're talking about copyright today, we're talking about duration. Video games are going to be copyrighted probably until long after most of us in this room are dead. Pac-Man's still very much under copyright despite how old it is. So if you're thinking about making fan games, you have to keep that in mind that it's still something that is very legally protected. I've also got a couple numbers here on copyright filings. Generally, when you create something, you already have an inherent copyright in it. That doesn't necessarily mean that you have legal protections in it. So for example, if you want to sue someone for infringing your copyright, if someone's knocked off your work, you want to stick it to them, you have to have a registration. Registration is a very simple thing. It can be done online. I always recommend calling a lawyer anytime you're doing anything legal when it comes to your games. But it's one of the most inexpensive forms of intellectual property that you can go for. And you can see it's 35 or 55, depending on the work that you're using and what you're doing with it. What is fair use? Fair use is an affirmative defense to copyright infringement. I always have to kind of qualify that a little bit, but essentially what it means is it's not a get-out-of-jail-free card for copyright infringement. The way it usually happens is someone makes something using someone else's work. Someone makes a fan game. Someone reproduces some artwork. The original creator comes after them and said, you knocked off my work, and I'm suing you for it. I'm upset because you made money off something I made. Someone will say back, well, it's a fair use for some reason. You know, it's out in the public domain, and that's another term of art that I don't want anyone to throw around too loosely because it has very specific implications. But an affirmative defense is conceding that you're already guilty. It's saying, yes, I did infringe your copyright, but I have an exception that makes it okay. That should never be your first line of defense when someone's calling you out on something. That should be the last defense you make. It's very important. This is kind of the definition that we have for fair use. This comes out of the 1976 Copyright Act. Believe it or not, we didn't have it codified until 1976. All of our original notions of copyright are carried over from England from several hundred years ago, back when it literally meant just the right to reproduce books. We've had to change it many, many times over the last 100 years. And in 1976 was the first time we wrote down the fair use exceptions. And the idea is there are circumstances where you can use someone else's work and it's not copyright infringement because it serves some kind of public interest. And what that means is it falls under one of these 4 different kinds of factors. This is what courts look at, and this is what they consider when they're trying to establish whether or not something is fair use. The first and the fourth are the most important. The purpose and character is the first thing courts will look at. They want to try and get a general gist, a general vibe of why you're using the work, what you're using it for, and then they kind of tackle the next ones. The nature, very important. The amount that you're using, that definitely comes into YouTube videos, which I'll get into a little bit later. The effect of the use on the potential market. This is the most important factor that they look at. Because if you're using someone else's work, and say, for example, that I want to make a fan game based on a pre-existing property, will people be less likely to buy the original work if my work exists? If that's true, I'm probably not going to have a fair use defense available to me, at least in the legal system, at least the way the judges look at it. So what I'm going to do right now is I'm going to go through a couple different kinds of fan games, a couple different ways that people use other parties' content, and how that tweaks those 4 factors that we just looked at. I'm going to look at hacks and mods, remakes, sequels, and clones. I'm going to go into exploits, and finally parody and satire, because that's one of the things I get the most questions about. Now, before I move forward, how many people in the audience are game developers? Good chunk. How many of you are artists? How many of you are business or industry folks? How many of you just dig games and it's a Sunday afternoon and you wanted to learn about law? Rock on. I'm always happy to see people excited to learn about law. Are you guys enjoying GDEX so far? Woo? Hell yeah, my people. Hacks and mods. These are 2 of my favorites. I wanted to give it a little bit of a Halloween spin today because it's kind of spooky. The one on the left is an interesting one. It's called Phantom Sonic. And I need to be more careful with my clicker when I do things like that. This is a really interesting game. It's a reskin of the original Sonic game from the Genesis era in 1991. Basically, a zombie demon Sonic chases you through all the levels. It's scary as hell, man. Any Sonic fans? Awesome. See, that's what I like to hear. So what they did is they took the original code, they took the original game, they added some new gameplay elements, and they added some new palette swapping. You can spin it one way or another. Hacks and mods kind of amount to the same act. You're changing the code, you're changing the game. Hack is kind of the word we use that has kind of a nasty spin to it. Mod is a little bit more positive. Someone says, hey, you hacked my game. It's like you're calling them a jerk. But if it's like, hey, that's a cool mod you made, it's like, hey, you made something new and interesting. The game on the right, Super Mario Brothers Crossover. Is anybody familiar with that one? It's the original Super Mario Brothers game, but it added new characters and new sprites. So you can play as Mega Man, you can play as characters from Contra, all in the original Mario game with different power-ups. It's kind of a cool crossover. If you're a big Nintendo fan, you like all of those games, you can kind of play them all in one place. Remakes, sequels, and clones. Similar, but just a little bit different. So Metroid 2, Pokemon Uranium, and my personal favorite, Jewel Block Crush Puzzle. The most generic knockoff I've seen in a long, long time. Available in the Windows Store, actually. So all of these, like the hacks and mods before them, take someone else's content and they tweak it, they add to it. But here they're adding a little bit more of their original content. Metroid 2 is a fan-made game, a reimagined kind of sequel to the Metroid franchise. Tons of new content, all new sprites, all new levels, but the same general feel of the original game, but wholly a mostly new product. Pokemon Uranium, same vein. Whole new Pokemon game, whole new Pokemon, all new characters, but a third party's idea, third party trademarks and copyrights that were not licensed. And finally, Jewel Block Crush Puzzle. It's the worst mashup of just every game you've seen in the last 10 years on the mobile market. They'll never hear me say that because I don't know where they live, but I'm guessing it's not in the United States. Exploits. This is another way that people tweak original content. Most of you are probably familiar with the Game Genie or the Game Shark. These were physical contraptions you plugged into your consoles that could enable debugger modes and basically turn on cheat codes. Extra lives, extra levels, extra skins, extra textures, all kinds of new content. But not necessarily licensed by the original creators or within their vision of what they wanted the game to be. So if I'm making a game and I want my game to be hard and challenging, and all of a sudden there's a contraption that lets people skip all this work that I did, I wouldn't be too happy about it. Pokevision, similar kind of thing. Anyone familiar with Pokevision and Pokemon Go? Probably everybody, right? Did anyone make it out to that Pokemon meetup on Saturday night out in the park? It was awesome. So there were tons of kids in Halloween costumes, but they were all dressed up like Charmanders and different Pokemon. So like you're out in the park catching Pokemon, there's actual little Pokemon running around. I was like, man, they went from VR to actual reality. This is awesome. Or AR, excuse me. So what they did here with Pokevision, for those who might not know, is a big element of Pokemon Go is you have to walk around and find Pokemon out in the real world using GPS and other tech. So what Pokevision did was it created a log based on metrics within the original code to kind of let people cheat and figure out where Pokemon were. And in effect, it kind of took a lot of the fun out of the game. A big point of Pokemon Go was actually going out, walking, kind of searching for Pokemon. And if you could find them on the map, that kind of defeats the whole purpose of the game. So Niantic got really cheesed and ended up sending cease and desist letters to the folks who made Pokevision and wanted them to take it down, remove it, because it didn't jive with their vision for their game. So even as cool as it is, it wasn't something within the original scope. Or, alternatively, maybe it's something way too within the original scope, because Pokevision is something you could see Niantic releasing themselves. That might have been something that they could have created 3 months, 6 months, a year from now as an expansion or a new feature of their game in a new update. And that's another feature that comes out a lot in fair use defenses, is some people will say, hey, the original creators aren't doing anything with this property, they haven't released any sequels in a while, they haven't done any new content. I'll make some new content, and I'm not really hurting anyone because it's something people like, and the original authors, they're not interested. That sounds good, but from a legal perspective, it's not, because they've got, again, life of the author plus 70 years, or at least 100 years if they're a company, to make those tweaks themselves. So, and part of that is the right not to if they don't want to. So when you have exploits like this, you're kind of stepping on the toes of the original creators. And as much as it might be something that people want, or as much as it sounds like a cool idea, it's not a quote-unquote fair use. Parody and satire are a couple other things that I get questions about all the time. You see a lot of games that get made, a lot of them are making fun of or lampooning existing properties. And all the games up here are really cool. I know, because I actually made one of them. So on the left is a game called Oregon Trail. It's an awesome parody satire game, a spin-off of Oregon Trail, with zombies and dysentery, as most of them do. Awesome game. Awesome game. All original content, just kind of inspired by the original game, but definitely making fun of it the entire time. Mario Kills Tanuki, a little bit less fun. This was a game put out by PETA. Some of you who might have been in my talk last year know that I do this all the time. But PETA wasn't too happy with the notion of Mario wearing fur. So they decided to create a spin-off game where you play a skinned raccoon chasing Mario for your fur back. It's a very gory kind of game that isn't exactly very kid-friendly, but it makes a very strong political statement, which makes it fall within satire. And the game all the way on the right is a game I made in a game jam a couple weeks ago, inspired by Stranger Things, with my friend Tom Caprell up there, who helped me out with a lot of the pixel art. And what we did with that game is we made a top-down bullet hell kind of game where you play as M in the Inside Out, shooting various Dungeons and Dragons creatures. Not so related to Stranger Things, but definitely inspired by. And one of the things I did with it to make it a little more fun is, since I know all the parody satire rules, we were very close within all the tight margins of what we could do and what we couldn't do. So again, parody and satire, just like all of the other games that I just went through, just like clones, just like hacks, you're using original content that maybe you didn't create yourself, usually without the permission of the original creators. But through the different games that we've looked at, parody and satire fall closer on the end of the spectrum to being a fair use than any of the other ones. Because parody and satire are actually something that are very well respected within the legal community and our copyright laws. There is a big public policy incentive towards parody and satire because it falls very closely within free speech parameters. The other ones, not so much. And one of the big reasons that some of those other examples I gave don't fall within clear-cut free speech protections or fair use definitions is because, for the most part, they're commercially motivated. A lot of the times they're offered for sale. So when we go back to those 4 factors, you'll see that it is affecting the marketplace for original games because you're cutting in on that action of the original creators. Now, someone always says, but wait, what if my game's for free? Right? That's what always what everybody says. They say, well, if I put it out there for free, they really can't do anything about it, because now it's not a commercial purpose. It's out there for free. I'm not even taking ad revenue. Is that okay? Not always. You might be getting out of the woods on copyright issues for fair use, but you might be getting into trademark issues. And this is just an example of how there's so many different areas of law that you can kind of run afoul of. One of the big aspects of trademarks is brand recognition and brand quality. If your game doesn't jive with the original message of the original creators or the original content, you might be diluting their brand name or their recognition or their reputation within the community. There are tons and tons of mods and hacks and clones out there. How many Metroidvania games are there? Tons of them. And they're not always as good as the original Castlevania or Metroid games. So if that is somehow diluting the, I guess, the people liking those original games, you're not in copyright trouble anymore, but you might be in trademark or branding recognition problems. So what I always like to remind people is that there's a difference between fair use and fair use. The inflection makes no difference, but what it comes down to is that fair use is a legal term of art. It's that affirmative defense I talked about for copyright. It amounts to an affirmative defense to copyright infringement. When people say, hey, what I did, it's a fair use, right? What they mean really is like, I'm not hurting anybody, it's justifiable, it's like a moral statement. They're saying, I'm not hurting anybody, I've got good intentions. But that's not really what the legal system is concerned with. More than fan games, fair use comes up all the time on YouTube, because one of the most popular things on YouTube is Let's Plays and video game reviews. And it's real hard to have a video game review without talking about the actual game, or showing gameplay footage, or using the name of the game. How do you talk about something without using any of the original content? And it's a big problem, actually, because we want there to be reviews of video games. Lawyers don't have any problem with that, and usually original content creators don't have any problems with that, unless the reviews aren't good. As long as the reviews are good, people are happy. But there has to be a fine line between how much you take, because in order to review something, you don't necessarily have to use all of it. So I mean, I love Let's Plays. I watch them all the time, and a lot of the Let's Plays I watch are full gameplay playthroughs, especially like speed running. You want to see someone go through the entire game, start to finish, fast as they can, and you need to show all of that content. Technically, though, that's a total copyright infringement of the entire game, because when you do that for a game like Mario, it doesn't create such a big problem. That game's been out for a long, long time. Everybody's played it. Everybody knows how it ends. There's no spoilers when someone speedruns Mario. But if it's a new game, and if it's got a very strong focus on narrative, so for example, a game like That Dragon Cancer, where it's really more of an interactive novel or a movie, it's got a lot of story, a lot of dialogue, some twists. If you watch a Let's Play of that, and someone plays the whole thing through, you've just completely nuked someone's necessity to buy that game to see that story. For a game like That Dragon Cancer that's an indie game, that can really hurt their sales, and that can keep them from making future products. So that's what copyright is kind of designed to protect, is someone's ability to put something out there and have people watch it for the first time. So there's kind of this push and pull right now between old school copyright branding and protecting people's work, because we want to incentivize people's ability to monopolize their creations, sell them, produce them, and put them out there in the universe, and this kind of sharing mentality that people have online. And it's really changing the way lawmakers are looking at copyright. Everything I've kind of talked about so far gets into transformative use. So if you're using someone else's stuff, and if you want to fall within fair use protections, generally, your best chances of acquiring a fair use defense is providing something that has educational value and that's non-for-profit. As soon as something becomes commercial, it very quickly begins to lose its fair use status. It's a much harder hill to climb when it's commercialized. Transformative, and what that means, that's another legal term of art. Something that's transformative is when you're putting more into something than you're taking out. When you're adding more new speech on top of old speech. So if you're a Let's Player, if you're a Twitch streamer, you should be asking yourself, why do people tune into my channel? Is it because they want to watch all the cutscenes in my Halo walkthrough? Or is it because they want to hear what I say? Is it because they want to hear my perspective, my input? Is it because I'm funny and they want to hear my jokes? Or is it because I talk about topical things and they want to hear my input? If you're a streamer, if you're a YouTuber, the push should always be on what you're making, because that swings more into a transformative use. That'll put you in a much better bargaining position when it comes to those factors later. Now, DMC takedowns, this is something that comes up all the time. People put some amazing content on YouTube, and all of a sudden, YouTube pulls it down. It's gone. YouTube is very strict about any time they get a call from someone who owns content. So for example, say I'm Steven Tyler of Aerosmith, and someone has reposted my video for Walk This Way. And I'm not getting any ad revenue off it because it's on someone else's channel. All Steve Tyler has to do is, well, call his lawyer, and then his lawyer will call YouTube and say, hey, that video is our copyright, take it down. YouTube doesn't think twice. They pull it down automatically. A lot of it's even automated. No human eyes ever see it. It just happens. And then the burden shifts to whoever posted it the second time to put it back up, to say, oh, no, it's okay that I put it up there because it might be a fair use. But that's all about terms and service. That's not, you're not in a courtroom when you're doing that. That's just YouTube's personal policies. But DMCA takedowns have become just so rampant lately because so many people are creating content, reposting content, sharing content. Copyright is just all over the internet and everything you see, whether it's a Google search or a YouTube video, it's everywhere. And where that gets to be a problem is sometimes people use that as a sword to silence speech that other people are making. Some large game studios, I won't say which ones, are very aggressive in their DMCA takedowns when it comes to bad reviews of their games that might have to do with people who might kill other people or scale buildings or ride in pirate ships. You might know what I'm talking about. And when they send out these DMCA takedown notices to these YouTube reviewers who are making bad reviews of the games, it's not so much that they're concerned about their copyright infringement, it's that they're trying to silence bad reviews because that's going to hurt their game sales. So it's leading to this new trend of DMCA copyright trolls, just as bad as patent trolls, but copyright trolls, trying to shut down content on the internet because it's negatively affecting their business. Now, machinima is another favorite thing. Does anybody like Red versus Blue? We've got some Rooster Teeth fans in the room. That is such an interesting thing to me because, first of all, I'm a huge Halo fan, so I love Red versus Blue. I've been watching it since the beginning. And you've got a group of guys who used the in-game skins and avatars in the game engine of Halo to create a whole series. They're using a lot of copyrighted content in that game, or in that show. And that's really cool. But what Microsoft did, they could have sent a DMCA takedown to them early on and said, hey, you can't do that. And in effect, they could have shut down that entire bit, that whole way of making film. But instead, they got behind them and were like, hey, this is actually a really cool show you're making. We kind of dig what you're doing. You're getting us a lot of advertising and a lot of cool promotions. So Microsoft wanted to incentivize that, so they encouraged them to make more. They actually partnered with them a couple times to do promotions. That's a rare kind of thing, but it's a great example of the way the industry is kind of embracing this new opening up of copyright laws, especially when you can make money, because money ends up driving everything. And the last example that I have here is an example of how the industry is changing a little bit to kind of embrace this sharing that's going on. It's called FUPA. It's a Fair Use Protection Account. And what happened here was you had some folks on YouTube who were getting DMCA takedown notices and getting copyright problems. And they kind of took their case to the internet and to Reddit and said, this isn't really fair, what's happening to us. We're just sharing things, we're just speaking our minds. We shouldn't, be attacked for copyright infringement for sharing our thoughts. And there was a GoFundMe account to raise money for their legal fees. And they ended up raising way more than they ever needed. But all of that surplus money they put into an account for folks who need money for legal fees, but don't have it themselves. And that became the Fair Use Protection Account. Come on. Okay. So in conclusion, I think I busted out some new definitions on fair use that I think probably a lot of folks who aren't lawyers maybe haven't heard before. But my hope was to kind of share that with you and give you all a perspective of where it was coming from and where some of the lines are on fair use so that we can all kind of understand what is something that can be done and what's something that can't be done. And if you're interested in learning more about fair use or about implementing some more change in this area, like take to the internet. I really encourage everyone to have a strong presence about this because me personally, I'd like to see this open up a little bit more because as much as copyright is supposed to incentivize creation, in a lot of ways it is minimizing creativity because it's locking down ideas, which is kind of against its original purpose. But my favorite part of all of these talks is questions. I love hearing from all of you because you bring up things that I never thought of before. So for the next couple minutes, I think we have about 15 or 20 minutes left. I'd love to hear questions about fair use or any legal issues that you might have questions about in the video game industry. So just show me hands and I can call on people when necessary. With the hat in the front row. The question is if an artist makes some original asset and puts it on the internet and says it's free for anybody to use and then they change their mind, are they legally accountable for that? It depends. It depends on their wording. It depends on the context of how they use it. But first of all, every answer I'm going to have today is going to start with it depends because that's what lawyers do. So it depends, but it really depends. Good Lord, I need to stop being redundant. So what happens a lot of time is exactly what you said. Someone will make an asset and they'll put it on like the Unity asset store. And they'll share it because they want to see it getting out there. And then someone might include it in their game just to test their game. You know, maybe it's not going to be a permanent feature. And then the developer might either forget to remove it or they might decide, well, they said it was free, I'll just leave it in. It's not really hurting anybody and it works and it's cool. And that game might make a lot of money. So the original artist might see their work in that game and go, hey, I made that. I didn't get paid for that. I want some money. And then they might come after them. It's hard, but because all of this comes down to circumstances, like really specific things. But my hunch would be that if you put something out on the internet is forever. If it's out there and it's free and it's being traded, and if you yourself said it was free, I know if I was defending the second person who put it in the game, that would be my first thing to say. I'd be like, you put it out there, you said it's free, it's fine. Now, what is a big problem, though, is when you can't take that to the bank, when you can't like really believe that. Because there's a lot of asset stores where someone will say, I uploaded this, it's mine, I made it, you can all use it. But there's no way for you to actually verify that they actually made it. What happens a lot is someone will find something online, think it's cool, want it to be shared, upload it to a store, say that they made it, and now you're the third user in the chain of command. So like someone makes something, a second middleman is the person who reposts it and says it's free, and then the third person might take it, use it, put it somewhere. The person in the middle is in a big world of hurt because the first person can absolutely assert their rights because they never gave their permission and they made it. So the person in the middle might be vicariously liable for any copyright infringement claims for the first person because one, they took it themselves, but then two, they passed it on to other people. And depending on the circumstances and if there's money involved, first of all, you never want to be selling something that you didn't create, but you definitely don't want to be sharing something you didn't create either unless you have explicit permission. So it's a very sticky kind of thing. So, all the way on the end. Sure. The question is, when's the best time to trademark the name of your game or the name of your company or something that's important to you? The first thing I always have to say is trademarks are very tricky. They're deceptively simple. The way that the USPTO is set up, that's the United States Patent Trademark Office, most of your trademarks can be filed online. And the way that the form is set up, it looks very simple because they ask for some very basic information. They ask for the trademark that you want to protect. They ask for where you live. They ask for what the product is that you're trying to brand, where you're using it, some pretty simple questions, some questionnaire kind of things. And a lot of folks try to file their own trademarks. And I always have to say that's not always the best idea because even though it looks really simple, there are some very tricky definitions. Just like fair use has like a real world meaning and a legal meaning, there's a lot of legalese involved in trademark filing that makes it tricky. So always try and get some help at the very least if you're going into trademarks. Now, your question was about when is the best time. It depends. Generally, the earlier the better, but with an asterisk. So when someone is filing a trademark, the USPTO always wants to know, are the goods available in commerce? Are they being sold now? Is the brand being used anywhere? And that changes how your filing is put into the USPTO. So if it's already in use, if you made your game a year ago and you've taken it to conventions and you've had posters and it's out there and people have played your demo and play tested with you, it's out in commerce, but not necessarily, because if it isn't for sale, it's not in commerce. It's just something that's being shown. So what the USPTO asks for when you say, yes, it's in commerce, is they ask for proof. And that proof is called a specimen. And that could be a screenshot of your Steam store page, your App Store page. If it's a physical game, if it's a board game, they might want a picture of it for sale at Target or Wizards of the Coast. If you don't have that specimen, it's technically not in commerce. So what you can do then is you can file what's called, or you can have your lawyer file, what's called an intent to use form. And that's a placeholder filing. So it says, I'm not using this mark yet, but I have this really cool name that I want to make sure that I protect before anyone else gets to it, because it's really unique, it's really special, I want it. But it's not in use yet. So here, I'll give you all my paperwork, USPTO, keep it warm for me, and then when I actually have it in commerce, I'll file another form with my proof. Those are the two different routes that are the most common for most of my clients. So to your question of when do I do it, it depends on if you're in commerce yet, when your release date is, and of course, what your financial situation is. Because you're absolutely right, legal work costs money. It's a business expense and it's an investment in your brand, in your company, and in the game that you're making. So if someone's game is already out in commerce, they should be looking at a trademark immediately, as soon as possible, because they're already out there, it's already being used. Someone might see it and file a trademark. You don't want to be in a situation where your game now has a name that's trademarked by someone else. So usually the sooner the better, but with a couple special situations.
I have a question between damaging an IP and doing satire or parody.
It depends on how much money's involved and who's playing. So the question is, like, where's that fine line between free speech and intellectual property protections? At what point is what you're doing really hurting someone else's business to the point where they're going to try and shut you down? And is it worth trying to protect what you're doing? In that case, courts look at a whole host of different factors. And it depends what side of the country you're on and what the actual work is. And it goes back to a lot of those 4 factors for fair use as well. But for example, if you have a game that's marketed for children, exclusively towards children, think something like Disney, Pixar, something really family friendly, something wholesome, and someone comes out and makes a porn version of that game. They make something very explicit, something very violent, something very sexually explicit, but it has a lot of original speech, a lot of original thought, it has a lot of creative free speech elements in it. Courts are going to try and weigh all the options. They're going to try and weigh your right to say what you feel, to express yourself and your First Amendment rights against the financial interests of someone else and their branding. And it's kind of a toss-up, because a lot of times, like you said, they're kind of at odds. Courts are going to weigh all of those different factors. That line gets very, very blurry, and where it becomes a problem is, in order to determine that, in order to answer that question, you have to be in court for a long time. And that is why we don't have a lot of answers for these things, because a lot of the folks involved don't have a lot of money to play with. It's just kind of the nature of the system, where in order for you to get a judge to apply a rule and issue an opinion to your specific circumstances. Because remember, video games haven't been around that long in the scope of the legal world. They've only been around for the last 40 years. We only really have good case law for video games going back maybe 20 years that I would call good case law, because the laws we had for Pong are now very, very different from what we have now. Circumstances have changed a little bit. It's hard. It's hard. My thought, I always want to protect free speech as far as I possibly can. So, like, there was a game that went up on Steam a couple years ago. It was called Hatred. It was a murder simulator. You were a serial killer who tried to commit suicide by murdering people. It was super, super gory, had a lot of swearing and adult themes in it. And Steam took it down because it wasn't really something they wanted on their store. Internet got really, really mad. They said, like, you can't do that. You're censoring. That's against free speech. Well, they're a private company. They can do whatever they want. They're not the government. So balancing out the free speech against economic interests is always a hard thing. I can't really say where that line is. Can you give me an example? Like, what do you have in mind?
I think the Pokemon Go, or the Pokemon Black and Blue, is what they call it, and the sequel Black and Blue 2.
For sure.
To
It probably would be. And when it comes to things like that, Nintendo is very litigious. They're always the first person to kind of put their foot down to protect their IP. And one of the big reasons that this comes up all the time is intellectual property is very much a if you don't use it, you lose it kind of legal protection in order to keep your copyright, well, not your copyrights, but in order to keep your trademarks and in order to protect your branding, you have to be aggressive because the first time you don't go after someone for using your mark, the gates open and now everyone can use your stuff. And that's something that no one wants from a marketing perspective. So I really wish I had a better answer for you, believe me, but it's just one of those things where you have to look at the parties involved, how it's being used, and we really don't have a whole lot of. It was getting a lot of press. I think it was that they noticed because, and that's one of the things that's kind of funny about this, is you'd think that they'd be the most upset about really bad games that would tarnish their brand, that would kind of ruin their reputation. They're almost more threatened, and Nintendo, of course, in this situation, but most IP holders are the most threatened by really good games that compete with their own. Because Pokemon Uranium was a pretty good game. It maybe wasn't as good as the original Pokemon games, which are favorites of mine, but when you looked at it, it looked like a Pokemon game. It had the original trademarks and logos, it had similar names, the art style was really spot on. It looked like it very easily could have been a Nintendo product. And that's kind of Nintendo's worst nightmare. They don't want people out there making stuff as good as them. They don't want their fan base to think they can get their Pokemon games somewhere else. So Nintendo kind of used that as an opportunity to put their foot down and be like, no, we're not going to stand for fan-based games like this. And it's something that's come up before. Now, different companies have different approaches. Like Sega is very, very lenient when it comes to fan games. There's more Sonic hacks and Sonic fan games out there than anywhere else. And I've always been really interested in that because I'm a big Sonic fan. I always thought it was great because I was like, wow, there's more content out there. At the end of the day, it's not as good as the original, so I always end up going back to the well. But I've played some Sonic games lately that are really, really good. And I always wonder if Sega's going to change their policy because they've got a game coming out next year called Sonic Mania that's a throwback to the original 90s era Genesis games. And a lot of these fan games look the same way. So if I'm a Sonic fan and I'm confused, if I can't tell whether one's made by Sega or someone else, that's not good for Sega's branding and it's not good for their IP. But the general rule is if someone's making fan games based on your stuff, as an IP holder with lawyers in deep pockets, you're going to want to kind of stomp anything that comes in. I don't know. I think that the reason that Nintendo was so upset about Uranium was because it was a very good game. And they've been very litigious lately just overall because, again, they had Pokemon Uranium. They had, it was Niantic with the Pokevision game, but also that Metroid game, which was a fan-made game in the best spirit, and it was offered for free, but they took that one down too. So I guess the lesson is at the end of the day, don't knock off Nintendo stuff. They don't care for it. Any more? Yeah, right in the front.
What about using recently scripts?
Sure. So the question is, what if you work in the industry and you're using some software or some assets from your place of employment to work on moonlight projects, working on something outside of it, fan projects, personal projects. Where's the disconnect there? Like what legal issues are there involved? It depends what state you're in a lot of ways. So especially in technology, there's been a longstanding tradition that employers kind of get first crack at any of your homebrew stuff because if it's, the term of art, the legal phrasing is within the scope of your employment. So if you're hired by your employer to make a particular kind of software, and in the course of making that software, you invent some new software, discover some new software that could be of use and profit to your employer, the idea is, since they created the circumstances that led to that creation, or they gave you the tools that led to that creation, they should have first dibs on whatever comes from it, the fruit of that labor, because it's within the scope. That's been changing a little bit lately because so many people do homebrew projects. So many people do have night jobs and side projects that's shifting more in favor of employees over employers. It used to be very strict. It used to be if you made something, your boss got it no matter what, even if it was completely unrelated. Great example of that is Steve Jobs and Wozniak when they made the Apple II. Wozniak had to take it to, was it IBM? Do we have any other history folks in the room? I think it was IBM. Wherever Wozniak was working, he had to bring it in, the original Apple computer, sorry, not the Apple II, had to bring it in and show it to them because they might have dibs. And they looked at it and they went, no thanks, never mind, it's made of wood. Worst decision they ever made. But that's just an example of they had first dibs. So generally, This comes down to employment contracts too. Generally, most employment contracts in tech fields will have wording about side projects. But if you're making something that is really unrelated to what you do at work, that's going to be more in favor of you. If you make bank software during the day and you make a Unity game at night, that's not within the scope of your employment. So chances are it'll probably be with you. But if you have an employment agreement that speaks to IP, look there, and then you'll probably get your answer. In the back with the beard.
Does using open source software
It does sometimes. The question is, if you're using open source software, does that affect your ability to sell that product or use it somewhere else? What restrictions are there, if any? Again, it really depends, but a lot of that is more of a business answer than a legal answer. There's always this push and pull between like what the legal system actually says, what it protects, and what the hard law is, and what the business kind of procedures are, what the normal course of business is, and of course terms of use and service contracts, because a lot of these questions are decided by contract, not statute. So if you sign the terms of service, if you click agree to terms and conditions that you won't use it for commercial purposes, and then you use it for commercial purposes, now you're in breach of contract, which doesn't have to do with any statute about open source software, but you agreed to something and you reneged on it. So it's a whole other thing. Like that's mostly governed by contract in terms of use more than any particular legal statute. Sure, yeah, if you're drawing IP from multiple sources, you can get hit from Nintendo, from Capcom, from Sony, from everybody. Anything that you use, they could all have a claim on you. And from their perspective, it might turn into like a class action against you. Usually it goes in the opposite direction. A bunch of little guys go after big fish instead of the opposite direction. The 5 biggest studios out there probably aren't going to all try and sue one little guy who made a fan game. Again, you never know. I can't say. But yes, multiple people can come after you. But I just got told that we're actually out of time. So first of all, I just want to thank everybody for coming by, seeing me on a Sunday. I had a lot of fun talking to you. And hopefully I'll see you all next year.